Dr. S. Sandy Sanbar and I would like to invite you to go to trial with us. We will be dealing with an actual case. These are the facts of the case. Of course, the names have been changed. If you will, let me set the scene for you. Imagine that the plaintiff, the defendant, and their attorney, the court reporter and the bailiff, the jury, have gathered in the court. The judge enters and asks everyone to be seated. The first order of business for the judge and the attorneys for both sides is to select the jury. This is, of course, called voir dire the jury. Now imagine, if you will, that you've been selected to be one of the jurors. Now you're in the jury box listening to the next order of business, and that is the opening statement. Of course, both the plaintiff and defense attorneys are permitted to present opening statements. The judge will ask the attorney for the plaintiff to proceed. So remember, you're a juror. You need to listen intently. You will be the one to render the verdict at the end of this trial.
May it please the court, Your Honor, my fellow attorneys, ladies and gentlemen of the jury, as one of the attorneys for Mary, I shall make the following remarks. And these remarks represent the opening statement. The purpose of this opening statement is to give you, the jurors, a resume, a capsule form of what we expect to prove with the witnesses that will take the witness stand before you. If I could influence your judgment by my statements, I would be very happy, but I know I cannot do this, since what I say to you is not evidence. Nothing is evidence until it is sworn to from the witness stand. Nothing is proof, even though it is sworn to, unless you believe it. So the distinctions you will make are between lawyers' statements, evidence presented on the witness stand, and proof which you believe. Not only will you hear witnesses, but you will see graphic pictures and other information presented to the court for your consideration. You will get to know the plaintiff, Mary McIntosh. We will tell you what happened to Mary. Because the evidence to be presented to you may not come in chronological order by the witnesses who will appear on the witness stand, some of the evidence will be presented out of order. This happens, unfortunately, when we have to bring in doctors. And we are going to have several doctors here. Let me now direct your attention to the issues. First, by telling you about Mary. Mary was a 28-year-old, typical working mother who was in good health before September 1981. She was married with 4 children, now ages 8, 4, 2, and 1. As a mother, she took care of her children in daytime and worked at night to support her family while her husband worked at night. You will hear from Mary that after her first child in the hospital, she developed a strong dislike and fear of hospitals, and this is why she went to Dr. Lee, who had a special clinic. The doctor subsequently delivered 3 of her children, and through the years, Mary developed an uncommitted faith and trust in Dr. Lee. Following the birth of her 4th child, Mary and her husband realized that they could no longer afford financially more children. So placing her trust and faith in the doctor, she sought his advice regarding sterilization. So the doctor arranged for her to have her tubes ligated at North American Hospital, and the operation was set for September 25, 1981. Unbeknownst to Mary, the doctor had no authority to perform the operation, the procedure that he did on her. we will show you that the doctor held himself as an obstetrician and gynecologist. And we will also hear expert medical witnesses state that he was not a qualified gynecologist. We will prove to you that the doctor was allowed to perform the procedure that he did only when he is assisted by another doctor. Otherwise, he wouldn't be able to do that. We will also prove to you that the doctor performed the procedure in an improper manner. He used the wrong sponge. He packed the inside of Mary with a sponge that did not have a string attached to it. The string is a safety measure. Because he did not use the proper sponge that has the string attached to it, he left one sponge inside her. We will also prove to you that not only did the doctor use the wrong sponge, but also the nurses that assisted the doctor in the operation counted the sponges wrong. The surgery nurses reported that the sponge count at the end of the procedure was correct despite the fact that one of the sponges remained in Mary's abdomen. You will hear about the rules and regulations and bylaws of North American Hospital. You will hear about proper procedure that should have been taken in counting the sponges, and you will hear about the structure of the hospital, which is operated by its chief executive officer, whose duty it is to provide high quality care that must be rendered to all patients at all times. The chief executive officer is here with us today in the courtroom, Mr. John Crow. We will also prove to you that it was the duty of the hospital to prevent doctors from performing procedures when they are not authorized to do so. You see, the hospital is a watchdog. It will not allow any individual to perform surgery on patients in that hospital unless they have clearance by the hospital committees to do so. Otherwise, they are not allowed to do it. And we will prove to you that every doctor must abide by the rules and regulations of the hospital and the bylaws. Now, when Mary reached her home on the 25th day of September 1981, which was the day of the operation, she began having problems with pain in her abdomen, which increased, and then she developed fever and constipation. We will prove to you that on the 4th day after surgery, she went to the doctor's office because of temperature and abdominal pain and constipation. And indeed, over the ensuing 4.5 months, she visited the doctor's office on numerous occasions. And we will prove to you that at no time did the doctor perform proper laboratory tests to determine the nature of her problems. We will also prove to you that the doctor treated her improperly by burning the inside of her vagina with silver nitrate. We will prove to you that at no time did the doctor try to seek the advice or assistance of another physician or refer Mary to someone else that could be more qualified or more competent to help her. We will prove to you that during those 4.5 months after Mary's surgery, she was in pain and misery, and the doctor missed the diagnosis of having left the sponge in her. And finally, we will prove to you that after 4.5 months, when the doctor ordered an X-ray of her abdomen, the sponge was discovered inside her. And we will prove to you that the radiologist, the X-ray doctor, promptly notified the doctor and told him about the presence of the sponge. And we will prove to you that the doctor did indeed call Mary to inform her of the unfortunate problem. And he again asked her to trust him so he could remove the sponge. Evidence will show, however, that Dr. did not attend to her immediately. He was interested to go on a trip to Alaska, leaving Mary by herself. We will prove to you that on February 3rd, 1982, when the X-ray was discovered to find the sponge, the doctor called North American Hospital to schedule surgery 8 days later so he can go on vacation to Alaska. But medical witnesses will testify that a competent, qualified physician who is a qualified surgeon should have been consulted to remove the sponge. And expert medical testimony will be presented to show that the removal of the sponge is beyond the expertise of even a board-certified obstetrician and gynecologist, and that the removal of the sponge should be left to the general surgeon. Evidence will show that as a result of the delay in treatment and failure to consult or refer Mary to a competent surgeon, Mary ruptured her vagina and rectum and developed holes both in the rectum and the vagina, and therefore developed a connection between the rectum and the vagina. Then she passed the sponge through the vagina, after which she started having fecal material or stools passing from the rectum through the vagina. We will show that Mary had 2 subsequent surgeries at another hospital. And we're going to show you how her abdomen was opened and how her stools were diverted so she can pass bowel movements through her abdominal wall. And we will show you how she suffered and how she had to tolerate wearing colostomy bags and cleaning the colostomy holes. And then we will show you that after several months, when she had the last surgery to correct the colostomy after the connection between the rectum and the vagina was closed, we will prove to you that the hospital was also involved. It undertook to treat and care for Mary in a competent manner through its nurses. We will prove to you that North American Hospital failed in its duty to monitor the doctor's unauthorized surgery. Now, Mary is with scars, both mental and physical. She has severe problems with her bowel movements, and she has the threat of future surgeries hanging over her head for the rest of her life. We will prove to you that she got so depressed in this whole ordeal that she considered suicide. And as we contemplate the 3 surgeries that she had, we will prove to you that the surgeries were born of ineptitude, lack of knowledge, lack of communication, improper treatment, failure to diagnose, failure to refer or consult another competent physician, and delay in corrective surgery after the diagnosis of leaving a sponge was made. You will make the determination at the end of this trial, which will be an expression by you of the community attitude towards such treatment that Mary received and toward the substandard medical care which I said we will prove. Mary has sustained medical expenses of approximately $18,000. And she has lost wages in excess of $3,000. And we will prove to you that she will need medical treatment for an indefinite period of time. And for all the pain and suffering and loss of wages that Mary suffered in the future, we ask that you consider awarding her the sum of $1 million. And if you can afford this verdict, you must remember that it's not only for what she has gone through, but what she anticipates and expects to face in the future. Again, the pain and suffering, further problems with her bowels, further surgeries, loss of time, and the most important thing, the feeling of well-being and the peace of mind which Mary will never again have for the rest of her life. Thank you, ladies and gentlemen of the jury, and thank you, Your Honor. And now we'll talk about the final argument. During the final argument, the attorney becomes totally involved. There is indeed a total rendering of oneself to the jury, and it is almost always emotionally depleting. The attorney must rehearse the final argument and prepare well. One of the best preparations is to actually videotape your final argument. Record it and then ask one of your peers or others to criticize your actions, movements. This final argument deals with a woman that was 30 years old and was admitted to a hospital to deliver a baby. A few days later, she died of postpartum hemorrhage. May it please Your Honor, my fellow attorneys, ladies and gentlemen of the jury, I have prayed that I could present this case to you in eloquence. There is a time for living and a time for dying. On May 15, 1981, June died, and she was not supposed to die. Now we spend the time contemplating how she came about to die, whether she died by the ordained will of the Almighty or because of the fault of those who were entrusted with her body. If you believe that everyone would die when they're supposed to die, then there is no cause of action here. If she should not have died, if her death was unnecessary, if it could have been avoided, and if it was not avoided because of the fault of those who are here charged with her responsibility for her death, I trust that then you will have the courage and the wisdom to make that decision. The choice will be yours alone to make. Two doctors, two of them were sued, and they paid the amount which the court has charged them with to be exonerated from the death of this lady. You are not concerned with whether or not these doctors were responsible for her death unless you find that they were responsible for her death alone. That no one else alone here that is being sued is responsible for her death. His Honor is going to charge you, and he has permitted me to say this to you, that two or more can be equally responsible, and that the law does not take into account degrees of responsibility. So whether the doctors were more responsible or the hospitals were more responsible will be irrelevant to your decision. All your decision must be is, were the hospitals in any way responsible by their careless conduct for the death of June? If they were, the responsibility of the doctors becomes irrelevant. The hospitals become fully, entirely responsible, since they are the only ones here being sued. Now, did the hospitals do anything with June that would inflict upon them the burden of responsibility? Two hospitals in your community said to you that by the records in this hospital, in this case, and by the testimony, they did not in any way depart from good standard hospital care. Then they go further and say, however, even if we did, we ask you to find that that failure to comply with good hospital care did not contribute to June's death. They don't care on which issue you decide in their favor, just so you choose one of them. And it becomes necessary for me then to address myself to both hospitals, both issues. I will not undertake to suggest to you what I think your verdict should be. I think my presence here should suggest that to you. And I beg you to resist any efforts to persuade you by the defendant's counsel that their opinion that their clients should be exonerated should have any bearing on your judgment. You are not concerned with what I think your verdict should be or what they think your verdict should be, but you are concerned with the fact that you, sitting here as a jury, are the voice of the conscience of this community. What you say here today may very well extend beyond the confines of this courtroom. You will set the standards of this community for these hospitals. you will do it. You will do it by your verdict. If your verdict is not guilty, you will exonerate the hospitals or either one of them and say, you keep on doing it the way you did in this case because it's all right, it's okay. That's the proper standard. There is no other basis for you to render a verdict except that. Let me make that clear. If you find a verdict in favor of either of these hospitals or both of them, because they are your hospitals in your community and because you feel it might be financially injurious to them and they will be held responsible. If you are troubled about the reputation of these hospitals, your verdict may be justified by the evidence. It may indeed be the correct verdict, but your reasons for rendering the verdict under these circumstances would be wrong. You might very well bring the right verdict for the wrong reason, which you must not do because you are sworn by your oath and conscience to render only the right verdict for the right reason. What is the right reason? You must find, in order to exonerate these hospitals, that neither of them or both of them did anything that in your opinion was wrong at law, or that although they did something wrong, they did not contribute to the death of my client. That's the only basis upon which you can render a verdict for the defendant. But let me be completely fair. If you render a verdict for the plaintiff because you're sorry for the poor children deprived of their mother, one of them who never knew his mother, and the other 3 children growing up without their mother, if you are so affected by this that you cannot reject them by an adverse verdict, if that is your reason, you may have reached the right verdict, but you would have reached it for the wrong reason. Because the only basis for having a verdict in favor of the plaintiff is that the hospitals or either of them did do something wrong, and that contributed to the death of June. So now I must ask you to bring your harrowed minds back to the events which we have been discussing for weeks. It is not an easy thing to ask of you. You have wallowed in the blood and the despair and the drama and the tragedy of this woman's final hour beyond endurance. I have tried to the best of my ability to spare you, and yet I could not spare you. You are the fact finders, and you have the courage, and your courage should be applauded. And regardless of your verdict, I thank you. I thank you during this grievous search for the truth. For the last time, I must remind you of the details to which you have been subjected. I shall do it only for the purpose of pointing out the way that I think may guide you for a meaningful verdict, because if your verdict is for the wrong reason, or if your verdict is wrong, and if it's determined to be wrong, you can never recompense for this, and you can never undo it. If you think you are right, whatever your verdict is, having searched your minds, having searched your conscience, having wrestled with the serious community problem that here exists, and you still think that the rejection of the claim of these children is justified, do not hesitate. You will be able to live with yourself without any problem. Let's see if it would be right. June entered the hospital, and it was not a sad occasion, even though it was accompanied by pain. She was going to have a baby, something she had looked forward to for 9 months. She had had 3 others. She had no apprehensions. She knew there was pain. She was a big girl. She knew that the joy that would follow the birth of the child would more than compensate for the pain. So she was prepared to endure the pain. And she had her baby, and she did nothing wrong. The doctor delivered her. No one suspected that conditions had been created in her which, in view of subsequent events, doomed her right then and there. And yet, nobody cared. So your first question will be, and it's not really a legal question, but a factual one, is there evidence in this case that anybody cared? If anybody had cared, would she have lived? Or could she have been saved if anybody cared? Do you think that the resident physician cared? Do you think that the resident physician in whose charge she was placed, who was employed by the hospital? Jurors, this hospital was not organized as a hotel in which people came for board, room, and cleaning. That was not the purpose of this hospital. That was a place for healing. And the hospital represented to the lady that they are going to do those things required for them to assist in her healing. Did they do that? You heard the evidence. The resident physician said, I have no responsibility to inform the doctor of the crisis which was impending. There was no need for him to tell him. Why didn't he read the records? Let us assume that the doctor should have read the record, and I think we can safely assume that. Wasn't it obvious by the final notes which the doctor made that he had not read the records? Was this a case in which one part of the hospital was warring against another by keeping silent to the detriment and eventual death of June in order not to inform the doctor because he had been derelict? What was the responsibility of this young man who was acting as a resident physician, who in the absence of the doctor was in charge of this lady? Did she have a right to rely that these things which happened to her were brought to the attention of those who would give her treatment? Did anybody care? You see, we come back to that again. Did anybody care? Or was she lying there as an area of controversy within a disjointed, non-communicative hospital where residents don't talk to doctors, where nurses don't make statements to doctors, where temperatures are not recorded, where hematocrits are not done, where everybody knows they should, but each one says, why didn't he tell me? Why didn't the other? Sure, the doctor was negligent, and he has acknowledged this and made payment thereof. Is the hospital exonerated? Do you believe that if your verdict says they are not guilty, that they will ever improve the conditions which you heard existed in this hospital at this time? Is that all right with you? Is that the way you think the community wishes these hospitals to be run? Is that the procedure and discipline that should be applied? You listen to the judge when he tells you what the law of the hospital's responsibility is. They have coexisting responsibility with the doctor. The doctor can overrule the rest of them. Had the resident said to the doctor, she has anemia, doctor, we better do something about it, and the doctor replied, mind your own business, the hospital would be exonerated from responsibility for that. You see, that's how simple it is. The doctor cannot make meaningful decisions unless he's familiar with the facts. By his negligence, he has not become familiar with the facts. And in this case, uniquely, evidence exists that he was not familiar with the facts, since he made no reference in his chart notes except one single incident of bleeding, which indicated he didn't know the other things. Thus, it became the responsibility of the resident physician. You heard my doctor who came up from Johns Hopkins, and you heard what he said. He said, I was chief resident at a hospital similar to this one, and I was in charge of resident physicians. The resident physicians were ordered that when something untoward, unusual occurred to a patient, that the doctor be notified and that the progress record contain it. This is mandatory. And he went further. He said, when a doctor gives an order which the resident physician believes is unwarranted, it is his obligation to go to the chief of staff of the hospital, first to the chief of the department of which he is residing, and if he doesn't agree with him, to go to the chief of staff of the hospital. This is how far his responsibility extends. Sounds strange, doesn't it? But isn't it a fact, as you heard here, that the resident physician stands not only to protect the patient against the invasion of conditions which, discovered by him, should be revealed, but stands between the patient and the inept, inexperienced, and calloused doctor. So I say to you, not only did the resident physician not care, did the doctor also not care? Nobody cared. So she was discharged with anemia. Bleeding, weak, no advice, no warning. Go home. You'll be all right. You're a big girl. So she went home, and she wasn't all right. 4 days later, she was in hemorrhage, and she came to the second hospital. Jurors, it's as though they had decided June was not going to be permitted to live, because the events that took place in the second hospital are totally inexcusable. Totally. Let's consider them. She was brought into the emergency room. She was in profound shock. She had an almost imperceptible blood pressure, and she had no pulse. What was done for her? Nothing for 1 hour and 10 minutes, lying in the emergency room with a resident in attendance. Nothing was done for her for 1 hour and 10 minutes. We could stop here. This would have been enough to kill her. She could not survive 1 hour and 10 minutes of hemorrhagic shock postpartum, no blood, no resuscitation, no doctor called, nothing. 1 hour and 10 minutes lying in a bleak, empty emergency room with one resident presumably looking upon her, hopefully with some compassion. But nothing done. And a medical technician said, I came in and looked at her, and she looked like she was just been in an accident. She was covered with blood. So what did you do? I decided to go and get her some blood. So I took a sample of blood from her, and I went back and cross-matched it. But I couldn't find anything that would cross-match it. How long did that take you? Oh, it took half an hour. Then what did you do? And I decided I couldn't use the blood. I couldn't use it because she was Rh positive. Well, did you write down Rh negative in the chart? No, I didn't write that. Somebody else wrote that. Who did? I don't know. Was there any place in the record that said this woman's blood was Rh positive? No. This is conceded. You don't have to read the whole medical records. There is nothing in it that says Rh positive. What significance does this have? 4 hours after the emergency room, June was in the operating room, and anesthesiologist was screaming through the hall, blood? What's he screaming for? Send me negative blood, he said. And they said, we have none. Why didn't he call for positive blood? Because he didn't know that she was Rh positive. Because the only thing in the record indicated that she was Rh negative. And you can't give Rh positive blood to Rh negative person. You can the converse, but you can't give her Rh positive blood. You really can, but they didn't know there was any. You heard evidence. She was Rh positive. She could have had Rh positive blood. She might have been saved. There was a slim chance at this point, 4 hours later, that she could have been saved. No blood. Why? Lack of communication. The medical technician did not inform the doctors that there was Rh positive blood. Why not? Because she said it was incompatible, and I wouldn't tell them. By implication, did she say, I wouldn't tell him because he might use it? Who was she to decide whether he should use it or not? This girl who became so tremendously upset when I asked her whether she didn't know that incompatible blood would do no harm. She said, what are you talking about? I said, didn't you know? She said, I'm not a doctor. He's the one who makes the choice. And she worked for the hospital. The hospital is responsible for her conduct. Now, why didn't the doctors up in the operating room send for blood? They didn't know it was there. They assumed she was Rh negative, so they wouldn't call for Rh positive. So they wouldn't send for any incompatible blood. In order for the doctor in the second hospital to have made meaningful judgments as to what to do, he was in the same position as the doctor in the first hospital. He must be informed. Now, the first doctor could have been informed by himself. The second doctor couldn't. He needed to be told. The blood in the operating room are at distances, and there was no method of communication except by the technician. So informing him was important, but there she sat, treasuring the blood and refusing to part with it, depriving the patient from that blood because she did not know that he could have used it safely and possibly saved her life. So there lay the patient on the operating table, June, no blood pressure, blood oozing out at diminishing rates, not because she was getting better, because there wasn't that much blood left to bleed. The blood pressure had dropped so that the exit rate of blood was a tiny seepage. She did not have enough to bleed hemorrhagically anymore. Now they began to give her massive blood. Hours of no blood, profound shock, now massive transfusions. Let me remind you of one more thing. Let me remind you that all those blood transfusions that were given, 23 pints of them were citrated. Do you remember the evidence? You had to put an anticoagulant into the blood or else it will coagulate because it has to be stored. It would have coagulated unless the anticoagulant is placed in it. She got 23 pints of blood in which the anticoagulant was in it. As fast as the blood was poured in her, it was pouring out of June. Why? Because all her blood was being replaced by citrated blood, and none of the blood that was given to her was going to coagulate. What was the cure for that? Calcium gluconate. So the doctor who was in the operating table said, I gave it to her. I gave her calcium gluconate. The hospital did not know that he was going to say that. I gave her calcium gluconate. So the hospital pathologist who was in charge of the drugs came in and said, well, he may have given it to her, but if he did, he must have brought it with him to the operating room because we had none at the hospital. There was no calcium gluconate. Jurors, this was the standard which led to the unnecessary death of a young woman. Will you approve of it? I suppose I could harry you by discussing her last hours. She died alone. No one was with her, and her death was not peaceful. As she approached death, when they had given her up, she tried to call for help, and the record indicates that she said, please help me. No one could help her. It had already been done. It was all finished. Members of the jury, June is dead. She has been in her grave for over 3 years. The result of your verdict will have no effect upon her unless in some way we have never determined that she's able to look down and see your deliberations and your verdict. But it will not help her. What it may do is constitute a monument, which I pray will put her forever to rest and would end this tortured litigation. 3 years you have seen in this case concealment, evasion, and even on 2 occasions perjury. We understand that in a conflict of adversary situation these will occur, but my honorable colleagues would never be parties to such things, and I beg you to forgive the fact that they have happened. These are testimony to the weakness of men who try to absolve themselves of the assumptions of the awful responsibility of having killed someone needlessly. So you see, your verdict is important. It may very well be the most important decision you have ever made. Either way, if you find that the defendant is not guilty, you will have approved a system of hospital practice and will have exonerated fault. You will have given approbation to a continuance of the conditions you heard described. If this is your choice, if you feel you must, you will. But if you think it's wrong, if you think it ought to be stopped, by your verdict you should say to these hospitals, these are human beings, small human beings, but human beings, important within their little family, if not to the rest of the world. Treat them with tenderness. Treat them with love. They came to you and offer you their bodies, asking only, do for us what needs to be done. They entrust themselves completely to you. Your responsibility must be commensurate with the obligation with which you assume. We do not assume that you hurt June or killed her because you wanted to. We think you could have saved her. We think you should have saved her. So we can say to you, mend your ways, because we find you responsible by your act and your failure to act for the death of June. Thank you very much. That substantially would have been the summation except for the argument on damages. It is important to note the need to have the jury make their decision and impress upon them that when they finish making their decision that they're not through, because they have to go out and live with it. If you watch the eyes of the jurors while giving the final argument, you could see their eyes turn inwardly upon them, upon themselves, and they suddenly become aware that this is not the kind of thing that they would lightly brush off and go home. Indeed, jurors may go out and for hours deliberate in cases and then come back and they would tell you, what took us so long is that we got out there and for a couple of hours we were talking not about this case, but actually about something else. We started talking about safety in general for women, children, and then we talked about product liability, and then we talked about children and toys, sucking paint off toys, and then we started talking about automobiles. In other words, there was an arousal of understanding of the community need for the expression of the jury on a problem that concerned the community. Suddenly, the jurors are no longer just a jury speaking for themselves. Suddenly, they become elevated, not to the black robe business that many lawyers talk about. Jurors have no black robes. They're not judges. But suddenly they begin to realize that for the whole community, they were selected to express judgment of the community. What's the significance of this approach that some lawyers take? No longer will the jury permit their own inborn prejudices or experiences to affect their judgment, which they might otherwise do. They will no longer let the fact that there is an immoral issue involved which they ought to express because of their attitudes toward that. They simply become concerned, subconsciously, if you will, almost subliminally. They become involved with what will my neighbors think of my verdict. That becomes an important thing. You know, defense lawyers use this as capably as plaintiff attorneys if they believe it and do it right. What will my neighbors think? Suppose I meet Mrs. Smith tomorrow and she says, where you been? Oh, I've been on a jury. Really? Did you finish? Yes. We got a verdict. What happened? Oh, some lady was going to have a baby. She went to the hospital, and then she went to another hospital, and 10 days later she was dead. They didn't have any blood for her, and she lay on the bed and so on. Neighbor says, my God, what did you do? Oh, we found the hospital not negligent. And the neighbor would say, are you crazy? How could you? How could you find the hospitals? That's a kind of thing that goes on in a juror's mind. Can the verdict adverse to the plaintiff be accepted and condoned by the community? And if they try to announce it now, with what pride would the same lady say, what did you think I did? We clobbered those hospitals. We teach them not to do these things to people. And that community relationship is what pervades every case that is tried in front of the jury. Fortunately, the jury will be reluctant to punish a doctor or a hospital unless they are really bad. And that concludes the final argument.